come before the court today is City of Wadsworth versus Richard Urich. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do that, and reserve some time, when you come to the podium, please let me know how much and I'll try to keep track for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. I don't think any of your cases involve this, but should there be children or victims during your argument, don't refer to them by name, use initials or some other type of adjective. We've read your briefs and we are ready to proceed when you are. Mr. Morris, I guess you're just going to pitch a tent and stay in.
I'm getting comfortable here.
For today. All righty. All right. Mr. Weird?
Thank you, Your Honor.
Ready?
I believe he was not. I think he was over 18, I believe.
Thank you. Good morning, Your Honor. May it please the court. Patrick Leary on behalf of appellant Richard Urich. Your Honor, we're here today for a matter that was presented at the Wadsworth Municipal Court on a contempt charge. That charge originating from a court order that was given to Mr. Urich to not have any contact with Kimberly Tavener or her children. The contempt charge came about, as indicated in the briefs, that there was an apparent attempt for communication via technology to her son. And Your Honor, I'll have to apologize, I don't recall whether the son was a minor at the time, so I will use the initials ZW.
Call him her son.
Okay, or her son. Essentially, it was alleged that Mr. Urich attempted a Facebook wave to her son, and that was truly the basis of the allegation for the contempt charge. There was a hearing held on that matter where Ms. Tavener testified as well as her son and a police officer, and then we also presented Mr. Urich to testify during that case. We presented some assignments of error stating that the conviction is against the not supported by sufficient evidence or sufficiency of the evidence argument, manifest weight of the evidence indicating possible miscarriage of justice in this case, and that the trial court placed upon the defense, and specifically my client, Mr. Urich, an improper shifting of the burden of proof in the case.
Before you continue with your assignments, did you want to save time for rebuttal, or did I miss that?
Yes, thank you very much. I'd like to reserve 5 minutes, please.
Thank you. Go ahead.
So essentially what we had was the allegation contained in the contempt charge was that, again, Mr. Urich did a Facebook wave, and the testimony was that her son received this wave at some point in time after installing the application on his phone. The testimony was that he then told his mom about it. His mom had contacted the police department, and an investigation ensued, which led to the court filing a contempt citation for Mr. Urich. Also at the testimony was Mr. Urich, who testified that he had no basis of understanding what the contempt charge was actually for until we actually started going through the discovery process. Once we went through the discovery process, counsel, myself, indicated to him that it was due based in large part, almost in sole part, to this Facebook wave. Mr. Urich also testified that although he's somewhat unfamiliar with the Facebook Messenger application, that it was an inadvertent or accidental wave that was reached out to Ms. Tavener's son. That testimony was presented in that manner, and that's essentially what the evidence was. It was very, very brief, very light, and I believe that it was insufficient to show that Mr. Urich intended to violate the court's order. Specifically, we believe that just because of a Facebook wave that was unintended by Mr. Urich, that is not supported by sufficient evidence for a conviction. Also, that it would be against the manifest weight of the evidence and cause a miscarriage of justice, because the trial court lost its way in making a finding that an unintentional, inadvertent Facebook wave was actually an attempted communication to a protected person by the court order. Lastly, Your Honors, as indicated, we believe that the trial court improperly shifted the burden of proof to the client, to Mr. Urich, by stating in his decision just prior to the verdict that Mr. Urich did not prove beyond a reasonable doubt that the Facebook communication, again, this wave, was inadvertent or accidental, and I would point your attention to transcript page 87. The trial court indicates, I do see this as a deliberate attempt to just let her son know, hey, I'm still out here. That's how I view this, and I think beyond a reasonable doubt, that's what they've established. He goes on to say, you've claimed that it's inadvertent, and I tend to believe you have not established beyond a reasonable doubt in my mind that it was inadvertent. I think you sent the wave. A criminal contempt charge is the same, because it carries with it criminal sanctions and penalties, the burden of proof is beyond a reasonable doubt, which would then also indicate that the defendant has absolutely no burden of proof whatsoever in this case. Mr. Urich did subject himself to cross-examination by testifying before the court, and it was never an indication of Mr. Urich that he denied the fact that his phone sent this text message, but rather that it was an accident. He testified that he has also received Facebook waves and has also waved accidentally to other people, but the trial court found that this was his attempt at communication to say, I'm still out here and I'm still watching it. It would be our suggestion that if you're actually going to try and make contact or communication with somebody, you would follow it up with some sort of written language to further show the intent that you would have to actually make that contact. Like, for example, hey son, or hey Kimberly son, what's going on, or are you still around, or how's your mother, things of that nature. But there was no indication, there was no proof of that, and there was no other communication whatsoever other than what we believe was an unintended Facebook wave. So we feel that because the trial court improperly shifted the burden of proof, suggesting that Mr. Urich had a burden to show that it was inadvertent, that was an improper shifting, and that assignment of error should be well taken as well. The state of Ohio, Pali indicates in their brief that the trial court actually corrected the burden of proof, suggesting again that he found beyond a reasonable doubt that it occurred, but that was actually the last thing that he spoke, the trial court, before issuing his verdict, was that Mr. Urich did not prove the inadvertency of the contact beyond a reasonable doubt. Again, we would suggest that if there was a communication with some written text, or perhaps even the process of selecting a photograph to send to the person, that would certainly indicate an intent to violate the court's order. But here we don't have, the state has not met its burden of proof by showing Mr. Urich actually intended to disobey the court. Must show some sort of criminal intent, and if something is inadvertent or an accident, then how can you establish, the question would be, how could you establish that Mr. Urich actually intended to disobey the court's order of no contact? So, Your Honor, for these reasons, we would suggest that Mr. Urich's conviction for contempt of court is not supported by sufficient evidence, sufficient, reliable, credible evidence, and that his conviction for contempt of court is again against the manifest weight of the evidence. And we would also suggest that the trial court certainly improperly placed upon the defendant the burden of proof of beyond a reasonable doubt when he had no burden to do so. Thank you.
Good morning. Tom Morris, as police court. It's Tom Morris. I represent the city of Wadsworth and the state of Ohio. In order to sustain a conviction for indirect contempt, the state of Ohio has to prove beyond a reasonable doubt that there was a valid order. And in this case, the valid order was the sentencing entry. The judge entered a sentencing entry that said no contact with the victim, no contact with the victim's family, specifically the son that was involved. The defendant has to have knowledge of that order. He was standing there when the judge said it and was served with the sentencing entry. Certainly he had knowledge of the order. there has to be a violation of the order, and I think that's what the subject of the hearing was. Is there a violation of the order? Was their intent, seems to be the limit of it. He admitted it came from his phone. He admitted that he was the one that had control of his phone. It was his contention that it was a non-purposeful or an accidental dial. My kid calls it a butt dial, right? It's not something that he intended to do. It was something that was accidentally done, was the contention. The judge heard that. Everybody pulled their little apps out of their phones, and as we were doing the trial, showed what it took, the steps it took necessarily to do something like that, and the judge didn't believe it. He made a credibility assessment, saying, I don't believe that that's what you did. I believe you did something else. I believe you did it intentionally to show this young man that I'm still out here. So, heads up. It's an intimidation factor. That's what the judge believed, and the judge was the one who was there, who got to see the witnesses testify, saw the fear, saw the defendant testify, and made credibility issues based on that. That's the judge's role in the contempt hearing. There's also a question of law that was brought up by the defendant in this case. Did he get the right burden? It's got to be beyond a reasonable doubt. That's pretty well settled law. The judge at one point, and I'll just point out, that wasn't a written decision. He made that decision from the bench. And as the judge was doing that speaking ruling, he on 2 occasions said the exact right standard. I don't believe, or I believe the state showed this beyond a reasonable doubt. He knew the standard. At one point there was what I would argue was a slip of the tongue by a judge that would say something which can be interpreted as shifting a burden, although nothing from what the judge said shows that he actually used that burden. He used the proper burden. He said it on 2 separate occasions, and without a written ruling. We get what we get from the court. Obviously, the judge knew it was beyond reasonable doubt, and I don't think there was any violation of the law. He properly knew it, just didn't believe the defendant when he testified, and did believe the victim in this case. There was a valid order, there was knowledge of the order, there's violation of the order. That's indirect contempt.
Counsel, it sounds like the court, though, it seems to me like it's more than a slip of the tongue. I mean, it's not like he said, I find the defendant not guilty, and he meant to say guilty. He talked about the defendant not proving beyond a reasonable doubt that it was an accident.
Immediately prior to that, he said the state of Ohio showed their case beyond a reasonable doubt. Page prior to that, state of Ohio shows beyond a reasonable doubt. And then he said that.
Seems like he held both parties to burdens. Court speaks through his journal entries. I cannot get into his mind. I would certainly suggest after 22 years on the bench that the judge knows the proper burden. I've had many cases where he's told me that exact burden, but it says what it says, and I can't apologize or change a transcript. That was said. I'm not saying that it was transcribed improperly. It says what it says. But he said the proper one 2 separate times in different opinions, and that was certainly not the... if he was going to make the groundbreaking law of shifting the burden of an affirmative defense, he would have made more keynotes, and I don't think he did. So based on that, I think the judge has the discretion to do what he did, and he was the one who judged the credibility of the witnesses.
Thank you.
Thank you again, may it please the court, your honors. Certainly it may have been a slip of the tongue, but I think that what we're talking about, whether it be an aggravated murder case or whether it be a traffic violation, persons in this country have certain protections of the Constitution, and those must be strenuously enforced. And we're talking about a judge making a ruling from the bench, whether it be orally or through a written decision. We have to hold the judges accountable for how they issue rulings. And it's clear as day from the transcript, and I don't know if you would necessarily call it a concession from the state of Ohio, but he's certainly not contesting that there was an error in the transcript. The court certainly said At the conclusion of his decision, just prior to saying I find him in contempt, is that, again, you've claimed it's inadvertent, and I tend to believe that you have not established beyond a reasonable doubt, in my mind, that it was inadvertent. He clearly placed some sort of a burden of proof upon the defendant to come to his defense when the defendant had absolutely no burden of proof whatsoever. And we need to hold the courts accountable for those when they're issuing decisions and rulings about whether they're finding somebody guilty of an offense, or in this particular case, finding him in contempt of court and a violation of his own order. And I would also submit that Mr. Urich did not contest the fact that he knew what the court's order was. He had been through that before with this court, where this court had given him 20 days for the original case. So Mr. Urich knew that this was a judge not to be fooled with, which further, and in his testimony even says that. Turned to the judge at one point and said, "Judge, I know you were serious about it. You gave me 20 days for the first violation. I wasn't going to do anything to upset you or to cause me to come back into court." And I think that's further demonstrated by the fact that Mr. Urich testified he had no idea what the contempt citation was even for until I started going through the discovery process with him and found that it was a Facebook wave. Now, counsel for the appellee says that indicates that there was an actual dialing of the son's number. Well, that's not how the Facebook wave works. In fact, before this, it took me some time to figure it out, but if you open in the messenger, it populates your list of contacts, and that's populated by the contacts that are in your phone. If you tap on a name, it can inadvertently send a wave, and there's nothing you can do about it. It doesn't say, "Are you sure you want to send that?" Or "Do you not want to send that?" It sends a wave. And in fact, I think we've all probably tried to do it once this case was going forward. And again, if there was an additional piece of evidence, such as a further communication or an actual texting to the son about either his son or the mother, Kimberly, then I would certainly say that there would be sufficient evidence to sustain a conviction in this case, because not only would you then have to waive, but you would also have a written communication. I put this to akin or a likeness of, if there's no contact order or protection order, you're told that if you do come in contact with the protected person, you are required to leave, right? So if you run into them at the grocery store or the library, an unintended contact would be the two of you seeing each other, but then the person who has the protection order against them is required to then leave.
Okay, what if you inadvertently go on your way out?
Well, that's a good question. Is there contact? I mean, obviously at that point you would have an unintended contact if you both ended up in the grocery store at the cash register line together. I think that Mr. Urich would be under an obligation to either leave the store or go to a different part of the store until the protected person exits the place. So I think, again, this was an unintended, inadvertent, accidental communication. Mr. Urich didn't suggest that he didn't know what the court's order was. He knew clearly what it was. He'd been given 20 days for the prior case and knew that this judge was not fooling around. And with technology these days, even if we're not familiar with it, we know that technology keeps a record of these things. I think the only possible application that may still be out there is the Snapchat function, which is where the message or the contact disappears. Facebook is not that way, and Mr. Urich would know that record of that communication, even if it was just a wave, would be kept. Why would he risk either 30 days for a contempt citation or the balance of 160 days if the court had jurisdiction over him
And with
to
that,
impose that?
your time's up.
Thank you very much, Your Honor.
All right, thank you both for your presentations. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the website of the Supreme Court.
Thank you very much, Your Honor.